paragraph, and before this paragraph, under the paragraph A, it listed in fact 3 major things that will constitute armed robbery. I won't waste my time with the 2. I'll just go straight to the number 3. And that was what exactly the court said. That when the firearms define what armed robbery is, it is not just limited to the presence of arm alone. And you will ask yourself this question: why is it that a weapon that is fake, or let's say a weapon that is not even weapon in the actual sense of it, why is it considered not to be armed robbery? One thing, the court is concerned with the violence. The court is much concerned with the violence. Why is the presence of armed robbery? Because of the violence it poses, not even the apprehension of the fear. No, get it right. It's not just the apprehension of the fear, but the violence. And now, if you have done to someone what that gun can do, if you have done to someone what that gun can do, if you have done to someone what that cutlass can do, if you have done to someone what that stick can do, shall we then ignore the wound and say since there is no arm, then there is no armed robbery? So here the court submitted that in fact armed robbery is not limited alone to the presence of arm, but when there is wound, grievous wound, even wound at all, however grievous it may be, then this fellow will be liable for armed robbery. Thank you.
Wound during robbery, you have done, I wanted to use a curse word, but you have done the harm that a weapon could. You should be punished for it. But it shows that, or rather, it's common sense that you were not armed. Yes, it is simple. Armed robbery, you were armed during robbery. But wounding during robbery shows that you have done the harm that the weapon could have, and so you should be punished for it. But that doesn't mean it is Jesus Christ. That doesn't mean it is armed robbery.
Basically, what you are saying is that without the presence of an armed weapon, there is no armed robbery, if I'm correct. Armed weapon or offensive weapon, there is no armed robbery.
So can we insinuate from here that if you actually use violence, you have committed robbery without armed weapon, not armed robbery? Except you are contradicting the definition of the Firearms Act.
That section 402, subsection 2A, is referring to somebody who was in possession, or a colleague who was in possession of arm. Now, subsection 2B, what we fail to understand there is subsection 2B is the continuation of section 2A. Section 2B is still referring to the said offender. The word said is very, very important. Said offender. Who was the said offender? That is the person in possession of arms and ammunition. And that was why the case of Johnny Nwachukwu was concluded as not armed robbery but simple robbery. So that is it.